Karen Reed and Lindsay Clancy. There's a lot going on here, and I'm on top of it. Welcome to Lunchtime Law on the Margaret McLean Show. I'm a former prosecutor, civil trial attorney, and law professor, and this is where we take the legal stories dominating the headlines and translate what is actually happening inside the courtroom. Please subscribe, press the like button. I'll be following these cases happening right here in my state of Massachusetts, and some are happening right here in my county of Plymouth. You can find me right here every weekday at noon. It's usually live, but today I'm helping out with a fishing tournament on the Cape, so it's pre-recorded, but I'll be able to join the chat. So chat away. First, let's take a look at the lawsuit itself. So the witnesses claim that Karen Reed and Aidan Kearny, Turtle Boy, orchestrated a ruthless, years-long harassment campaign. They argue that Reed knew she struck her boyfriend, Boston police officer John O'Keefe, with her SUV, but then intentionally fabricated a framing conspiracy to deflect blame. The plaintiffs are Jennifer McCabe, Brian Elbert, Colin Elbert, and Brian Higgins. They're also known as the House defendants. And they're represented by the same high-profile lawyer who won a historic judgment against Alex Jones. So they say that this campaign incited nonstop online hatred and severe emotional distress, completely upending their lives. So the 50-page civil complaint details how the actions of Reed and Kearny upended the plaintiffs' lives. So, for example, Jen McCabe claimed she was subjected to targeted intimidation at her children's sports games, relentless online trolling, and protesters screaming outside her home. Brian Elbert asserts that the conspiracy theories forced him to sell his family home at 34 Fairview Road in Canton below market value and disrupted his retirement from law enforcement. Colin Elbert alleges that the public framing ruined his reputation as a young adult, uh, tying his name permanently to an M and conspiracy case before his career could ever even begin. And then, of course, Brian Higgins claims the public fallout compromised his professional standing as a federal agent and subjected him to intense personal security threats. While Karen Reed is accused of feeding information and funding the narrative, Aidan Kearny is accused of being the boots on the ground enforcer. They allege that Kearny directly filmed himself confronting the plaintiffs in public spaces, including following Jen McCabe to her kids' lacrosse game and a swim meet, plus showing up at restaurants where the Alberts were dining. And Kearny used his blog and social media platforms to direct his followers, and they're dubbed the Turtle Riders, to protest outside the plaintiffs' homes, call their employers, and post their personal cell phone numbers and addresses online. So Kearny also manufactured, according to them, and sold apparel and lawn signs featuring the plaintiffs' names and faces and generating revenue while publicly labeling them as criminals and cover-up co-conspirators. The crux of Karen Reed's defense is simple. She argues that her public statements blaming the witnesses were a fundamental part of mounting her criminal defense in the two trials against her and petitioning the courts. However, her legal team made a critical blunder. The plaintiffs filed an amended complaint adding new allegations about statements that Reed made to a third-party documentarian, Terry Mueller. So Reed's lawyers completely failed to address those new counts in the amended complaint. They didn't address them in their special motion to dismiss. It was obviously an oversight which shouldn't have happened. The plaintiffs are calling this a colossal mistake and are pushing for a default judgment on those omitted counts. They argue that because Reed's team ignored those specific claims, they legally cannot be dismissed under the anti-SLAPP motion. So today, July 14th at 10 a.m., Judge Mark Gildea held a high stakes hearing to sort out this exact procedural mess. He ordered both sides to submit their original digital Word documents to audit the exact timeline of this drafting error. So he must be shaking his head. He must have a headache, actually, a big one, because he's thinking, how did this possibly happen with all those lawyers? It was an oversight, clearly, but it was a big oversight. So the question now is, will the judge throw out the entire lawsuit using the anti-slap shield, or will this technical mistake cause the case to go forward on those specific counts? We'll see. So let's turn to Lindsay Clancy. Defense attorney Kevin Reddington attempted to bring in 16 lay witnesses to testify about their personal battles with postpartum psychosis. Basically, he wanted them to say, I heard voices too, I was overwhelmed, and I also went into severe psychosis where maybe I was out of my mind. I've been talking about this case with lots of people. In fact, I had a conversation last night with a male friend of mine who at one point worked in a mental health facility, and he didn't buy Lindsay Clancy's claim that she heard voices directing to her to commit those crimes. So the question is, would these witnesses be helpful? And of course, the prosecution objected. And I'd like to know what you guys think about that. Would you like to have heard from these lay witnesses? So let me break this all down or translate it. The issue is lay witnesses versus expert witness testimony. Under the rules of evidence, lay witnesses are limited strictly to firsthand personal observations of the actual events of the case. A lay witness can only testify to what they personally perceived regarding this specific crime or this specific defendant. Like, for example, somebody could testify about observations they had of Lindsay Clancy. They cannot give generalized medical or psychological opinions. They're not qualified to diagnose or contextualize an illness for a jury. So here's the rule. Expert witnesses are permitted to give scientific, technical, or specialized opinions based on training and education. So if you want the jury to understand the nature of postpartum depression, postpartum psychosis, or how somebody can actually hear voices, if you want somebody to get up there and testify and say, hey, it's a real thing, you must do it through a forensic psychiatrist with expert credentials. The expert can testify about, medical studies and clinical diagnostic criteria. But bringing in 16 citizens or lay people to give emotionally charged testimony about their own medical histories violates these boundaries, it violates these rules. The motion for a view of the property was allowed. It's now owned by someone else, and it doesn't look at all the same on the inside. Attorney Reddington wasn't in favor of it because of that. And he also doesn't want an overwhelming police presence. And the judge agreed with him on that. By the way, after watching the proceeding, I think Judge Sullivan is fair and reasonable, and both sides appear cordial with each other. They've all worked together before, and that's obvious. Judge Sullivan is also seating an 18-person jury, and that means 12 deliberating jurors and 6 alternates. So you wonder, why so many backups, right? Why so many on the bench? The judge is anticipating a marathon trial lasting 6 to 8 weeks. I can't imagine this lasting that long, and they never usually last as long as they say. So the judge denied the defense's request to sequester the jury so they won't be locked in a hotel room somewhere, but they will be under strict orders to completely stay away from social media and avoid any news coverage of the case. Sequestration of jurors is rarely done these days due to the expense, but Attorney Reddington claimed this case could warrant that due to its high publicity and people like me, discussing the case on YouTube and social media. And he specifically said, listen, I will instruct them every day to stay off social media and the news coverage. Let me ask you something. Do you think they really do that? I mean, I really hope so. I was a juror and I stayed away from any social media coverage or news coverage of the case, although there wasn't that much in the case that I was on. But for example, do you think the Karen Reed jurors stayed away from all of the online chatter? Tell me what you think in the comments. So, tomorrow on Lunchtime Law, I'll discuss what happened today in the Karen Reed defamation case, and of course, more on the upcoming Lindsay Clancy trial. Thank you again for tuning in, and I'll see you tomorrow.